IVM.
Hi and welcome to Know Your Kanoon. This is Amber from EM Nana Ventures, and in today's episode we'll be covering a very interesting topic of late which has been into the news a lot, and that is about the contempt of court and the constitutionality of certain provisions which were administered during such contempt. So I'm going to break this into two parts in terms of freedom of speech and expression, and one part in today which we're going to talk about is going to be regarding the contempt of court and what is contempt of court for all our listeners out there. Right, so I'm sure you would have heard of the recent case which happened with the senior advocate lawyer, Mr. Prashant Bhushan, and how he was sued for contempt, and many people did ask out that, what is contempt of court and why has Supreme Court awarded that particular, monetary implication on him. I mean, for all you guys out there, the contempt of court is covered by the Contempt of Court Act of 1971. Article 129 of the Indian Constitution talks about the law regarding contempt of court, which states that the Supreme Court of India shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt itself. Superior courts of records have the power to punish contempts relating to the judges of those courts and the proceedings therein. The principal aim of the jurisdiction is to protect the dignity of the court and administration of justice. So that is as far as Article 129 goes. Section 2C of the Contempt of Court Act 1971 defines the limits, the powers of certain courts in punishing contempt of court. Now, contempts can be civil, contempts can be criminal. The act that defines a contempt as civil contempt is basically an act which is of a willful disobedience to any judgment, decree, direction, order, writ, or other processes of a court, or willful breach of an undertaking given to a court. And criminal contempt, on the other hand, is pertaining to the publication, whether by words, spoken or written, or by signs, or by visual, representation of any matter, or the doing of any act whatsoever, which has further two clauses, which scandalizes or tends to scandalize, or lowers or tends to lower the authority of any court, prejudices or interferes or tends to interfere with due course of any judicial proceeding, and interferes or tends to interfere with or tends to obstruct the administration justice in any other manner. Now, this is the section, and as you would read through, laws are pretty complex in terms of explaining what and how they read in clauses. But contempt of court, as I would rightly like to put out in simple words, is nothing. It is obstruction of justice in terms of when the justice is being administered. In civil sense, it is nothing. It is that the order which was promulgated by the court has not been enforced to the core in the manner. There has been a way of maligning that order, or there are such implications which are being made which are not relevant to the matter and are done in order to lower the administration of justice which has been accorded in a particular matter. In criminal cases, it is somewhat a little different. Criminal cases, it is pertaining to the public in general whenever such an order is given, and the contempt here is pertaining to processes, system of justice, procedures which were used during that criminal proceeding, or it affects the public at large. The difference between the two being pretty simple, if I put it in simple words. Civil contempt is between two parties, where two parties are engaged and then there is an order which is being enforced. A criminal contempt, on the other hand, is where a public purpose is at large, and during those proceedings there is being something done. A lot of times, and I would like to compare this with just to give you an easy example with the Canadian jurisdiction, because we have some provisions in our constitution from their constitution as well, is that since we borrowed freedom of expression and certain other artifacts in a manner that they both amalgamate with your contempt of court, in Canada as well, the contempt of court is same as in India. Of course, there being the justice of truth finding, self-fulfillment, and public discourse. Contempt need not be direct. Contempt can also be indirect, arising out of a third party, which would also include in certain times reporting of any such kind, which might put the whole process in jeopardy, or which might in turn delay the administration of justice, or which might, in terms of any order of the court, be affected to the core, such as nullifying what the court has done and declaring that whatever the court is doing is not according to the principles. So it could be any of that. And a common example again is in case if you disrupt proceedings by being in the courtroom as well, where you're bound to deliver a conduct and you do not follow that. It is as simple as that. Now I'll break it into three heads to give you a simple gist of what the criteria for the ingredients or the criteria would be to constitute the contempt of court in India. The first and foremost ingredient would be interference with the administration of justice. There are different case laws to that effect of Supreme Court. One of the case laws is BP Sharma case law, right? BP Sharma versus UP is a case law where the Supreme Court had whether outrightly held that in order to constitute the offence of contempt of court, it was necessary to specifically prove that an actual interference with the administration of justice has been committed, right? And it was also held that if it was enough, if a defamatory statement is likely or in any ways tends to interfere with proper administration. So what it tries, I'll just summarize what it's trying to say. It's trying to say that contextually in operation, it should be established and mentioned that there is administration of justice, right? But it has to not be absolute and not be concrete in terms of the application. Interference could also be inferred. Interference could be indirect. Interference could also be presumed. So let's say if there are 10 factors, if you prove those 10 factors, then there is absolute interference. I just need to prove, let's say, 2 or 3 factors, which are sufficient enough to give effect that there is an interference that has happened when the justice is being given or committed. Similarly, the defamatory statement example, which is given is to this regard that in case there is an administration of justice and this particular case, there were certain statements which were made which were defamatory in nature. Just mentioning of those statements were good enough to mention that there has been an interference with the administration of justice. So to sum it up, any interference with the administration of justice that happens, I'm going to elaborate the case laws in the next part just to give you a better idea of what I'm talking about. But this is just to broad brush initially in this part. Right. The second criteria in this would be of scandalizing the court. Now, a lot of people would say what would be scandalizing the court, right? So would it be criticism? Would it be, adverse views? Would it be negative implications against the court? What would fall, in this? So it has clearly been upheld in various case laws around the country that and as a principle of law, which is in India and Canada and UK, which is all the common law jurisdictions, that simple criticism of court, which is being done in terms of deliverance of judgments, which they do in their due course of process, would not tantamount or would lead to contempt of court. It has to be of something of a nature which is rare, which is out of context, which is crossing the boundaries, right? And it is one that is exemplary in a way that it really affects the court and the reputation of the court, right? So something that impairs the administration of justice, something which hampers the administration of justice, those factors can still be considered. But a mere criticism about one of the judges as to how they operated in this manner, such that this is not correlated to the core of the case that took place or to the integral part of the administration of justice, it would not lead to contempt. Now, as we were talking about, what would impair the justice, what would hamper the justice? Well, defamatory statements, of course, once, but defamatory statements of a nature that really cause that particular statement to be believed. It lowers the dignity, reputation, likely to cause an uproar about the reputation of that particular person or how the world perceives him or her or the surroundings or the public is one. Number 2 is vilification of the judge. Now, the term vilification is pretty simple. It's used across all legal terminologies. Vilification means abusive in a particular way, that it tends to be completely absurd in context. Thus, if there is vilification of the judge, whether it is speech or writing, which is very abusive, it would tantamount to contempt. Now, if the judge is holding the court and during an administration proceeding this is done, then yes, the state will take action. The Contempt of Court Act will apply. But in case if it is between two parties in their individual contextual matter, then in that case, this would be a dispute of defamation between two parties and the court would have lesser part to do in terms of interference. This is the first part of things. The second part of things is in terms of considering the degree of harm or degree of damage that this particular statement, remark, action has caused during the administration of justice, right? In case if the actions are such that they are below, the standard of what would cause damage, let's say a simple discretion or a simple act which is unfettered but it did not lead to any such damage to the overall process of administration of justice, whether it is procedure, whether it is cross-examination of witnesses, whether it is submitting of evidences, exculpatory evidence, so forth, so on. If these matters are there, then they do not or will not qualify to fall under the contempt of court largely. But everything depends on nature and circumstances. It has to be seen. There is no set standard. It has to be seen in light and context of that particular case, right? The conduct should be thus of such a nature in context that it should not come to the notice, right? If it comes to the notice of the court that you're damaging it, that is the reputation and the administration of justice, then yes, there is contempt. Also, again, I'll reiterate towards the end of things, that is, personal dignity of judges or members of the judiciary is not the concern here. The concern, of course, is with relation to that. That is in terms of administration of justice. Any individual disputes, incapacity of office bearers would not fall under this particular head or section, right? I'll come to the next part, which is interference with the due course of justice. This is one of the most common. I've been highlighting these on top in terms of breaking it down, by giving you examples of what would be what. Interference with due course of justice is that in order to preserve, the proceedings of the courts from interference and to keep the streams of justice pure, it becomes the duty of the court basically to punish the contemner in order to preserve its dignity, right? No one has the right to claim immunity from law if the action of that person or the conduct with respect to the court proceedings obstructs the due course of justice, right? Another Supreme Court case here, which I read during my college days, was one of Pritam Lal, right? But it's a High Court case. There are different cases in Supreme Court also. I think Shamsher Singh versus State of Punjab is one of the leading courts, and I'm going to talk about that also. In this particular case, the court had upheld that that libelous statements such as libel, or which fall in the category of libel against the sitting judges of a high court, amount to interference with the administration of justice, and contempt of court was considered because it did hamper the smooth functioning of the judiciary, right? In Shamsher Singh case versus the High Court of Punjab and the Haryana, High Court of Haryana and Punjab, and was one where the Supreme Court held that if remarks are made against the judge and those remarks are scandalous, and they actually prevent the course of justice which is being rendered by the court by interfering with the proper administration, the procedure, it will tantamount to contempt, right? All these cases all tend to say that disrespecting the court, the procedure, the administration of justice in any way would constitute contempt. I'll also like to highlight a matter where, in one of the appearances, there was a questioning of the authority of the judge by one of the witnesses, in fact, and in a proceeding that also was held to be one of contempt. Also in Canada, let me highlight to you, there's a matter which is pretty well known as a principle of law, that in case when a proceeding is being heeded and repeatedly an individual is casting aspersions of nature that can totally be belligerent in nature, then that individual is either excluded after warnings from the proceedings. If he refrains from doing that non-stop and continuously, then there is subjugation of an application of contempt, including media houses. So any reporting that happens outside the court and any comments by media which tend to render indirect action also in Canada have been held to cause big part of contempt of court and interfering with the process of justice. Now, as far as penalty and other things are concerned, there are different outlooks and different views on this. The penalty varies, though it mostly does not extend a period of 3 to 6 months. The rate and amount could be fixed by the courts. So just to summarize, wherever there is a common law jurisdiction, whether it is Canada, whether it is Australia, whether it is India, whether it is Britain, all you need to see and have is that you are meeting the aforesaid criteria which is mentioned. This is it for just to give you an example of what contempt is in a very simple language. In the next part, I'm going to talk about in detail as to other provisions of contempt of court, as to how and where they fall. So please keep listening and let me know in case if you have queries on this. You can write into me on contact@amranaventures.com.
I hope you enjoyed that show. I'd like to thank our sponsors, Intel, for coming back to us. We love our sponsors. If you'd like to be one of them, do reach out. So really, really cool week on the network this week, right? Started off with a bang. Abhijit Ganguly was on Cyrus Says. Funny comedian. I think you guys will enjoy that. We had Dimant Parekh on Advertising is Dead. Dimant's the founder of Better India. Govindraj Athiraj is also on Uncle Please Sit this week. That's a really fascinating show which they talk about fake news. On The Habit Coach, there was a crossover event with Aditi Surana from Absolutely Right. I think you definitely enjoyed that. And last but not least, definitely a show I'd love you all to check out. We have a new show called This Round Is On Me. It's hosted by Gauri Devi Dayal. If you remember, Gauri and I worked on a show together called The Kolaba Cartel a while ago. Fun show. If you haven't checked that out, do check that out. But this is a show where she's talking to a lot of different people in the food space. Her first guest is Harsh Mariwala, legend in his own time. I think you'll really, really enjoy that show. But with that, we hope to see you again next week.
Advertising is dead. Yep, you heard me right. Advertising is dead. We're all in the content business now. Let's not call it news, TV, radio, etc., etc. It's all content, and we're in the middle of this weirdly exciting phase where all the borders and lines that have been drawn over decades has been swept away by this lovely thing called the internet. We're a show where we don't dwell on just the stuff that is now, but rather the wider stuff about advertising, media, content, and the whole goddamn circus surrounding it. Tune in every Tuesday for our weekly unboxing of the mystery box we used to call advertising. I'm Varun Dugirala, co-founder and content chief at The Glitch, and this is my new podcast, Advertising is Dead.